Hi, I'm Laurie Pascoe, a family law lawyer practicing in Ottawa, Ontario since 1977. I have produced a series of exciting action-packed videos on how to complete Ontario's financial statements. So to help my clients and anyone else in Ontario who is separating from their spouse or varying their separation agreement or varying a court order, so they can better understand and complete their financial statement. I have broken down my presentation into a series of videos. The first video is a general introduction to the financial statement, and the rest are mostly divided along the lines of the many different parts of the financial statement. To help explain how to complete the financial statement, I have created a fictitious client and a fictitious financial statement rather than having a blank statement. And where appropriate, and to understand the form better, I will at times discuss the law a little. Remember, these videos are not to be used as a replacement for legal advice. You should still consult a lawyer. Part 6, Property, Debts, and Other Liabilities on the Date of Marriage. Part 7, Excluded Property. And Part 8, Disposed of Property. Part 6, Property, Debts, and Other Liabilities on the Date of Marriage. This section is not found in Form 13, but only 13.1, as the value of property and debts on the date of marriage are not an issue for support purposes. This section will automatically be calculated by the computer, as it will take the total value of assets that were inserted under the subsections of Part 4, and then subtract the total debts as put in Part 5, for the values as of the date of marriage. Except the matrimonial home. If it is owned on the date of marriage, it will not be included as an asset on the date of marriage. It took a few years for the case law to settle this issue of effect of bringing a matrimonial home into the marriage. As the Family Law Act specifically says, a matrimonial home value is not a deduction from one assets for net family property purposes. However, because the definition of a matrimonial home is, quote, the home the parties lived in at the date of separation, unquote, if one brought a home into the marriage and sold it before separation, one does get the deduction because it is not a matrimonial home by definition, as one was not living there at the time of separation. But if at separation you are still living in the same home you brought into the marriage when you separate, then it is not a deduction. Of course, if you brought a matrimonial home into the marriage, you should have had a marriage contract. And to learn more about marriage contracts, please visit my award-winning, critically acclaimed website at www.thepascodifference.com and read all about marriage contracts and cohabitation agreements. So, for the next time, you do it right. Here's where you can find that important information for the next time you get married or start cohabiting. It is my opinion that cohabitation agreements are more important to have when you live with someone than if you marry that person, because the rights and obligations of splitting up in a cohabitation situation are less defined than rights and obligations when splitting up when you're married. Now back to the show. Excluded property. Again, this part is not in Form 13, as it is not necessary to determine issues of support. The Family Law Act, in Section 4, Sub 2, states the value of certain property owned by a spouse on the valuation date does not form part of a spouse's net family property. That property is listed in this part of the form and includes the following. Firstly, gifts or inheritances from a third party, not gifts from a spouse, but from a third party. And the gifts and inheritances are after the date of marriage. However, one does not include a matrimonial home if it was a gift or an inheritance. Secondly, income from property that was inherited or received as a gift from the donor or testator, the person who died, who expressly stated that the interest is to be excluded from the spouse's net family property. Therefore, if you inherit $100,000 and put it into a separate, solely registered bank account in your name, not the $100,000 would be a deduction and stated here because it was inherited, but the interest from that inheritance would only be excluded if the will expressly stated, or the person who gave you the money expressly stated, something to the effect, and thou shalt not be required to share the interest from this gift with thy spouse. Now, all wills drafted after 1986 would have words to that effect. Thirdly, damages or a right to damages for personal injuries, nervous shock, mental distress, or loss of guidance, care and companionship, or that part of the settlement that represents those damages. So if you're involved in an accident, make sure that you state what part of the settlement is related to those types of damages, which you want to be substantial compared to other types of damages for Family Law Act purposes. Fourthly, proceeds or right to proceeds of a life insurance policy as defined by the Insurance Act. Fifthly, property other than a matrimonial home, into which property referred to in the first four things I talked about can be traced. So for example, if you inherited money and bought a car with that money, you could deduct the present value of the car because you can trace it from inherited money. But if you spent that money on a vacation or paid down the mortgage on your home, you're out of luck. You don't get to deduct it. Sixthly, property that spouses have agreed by domestic contract not to be included in the spouse's net family property. If you presently have of these assets now in your possession, please put them and their value on the valuation date in this section. If you're relying on tracing provisions, number 5, please give me or your lawyer a written explanation as to how those assets were acquired to show how it came to be an excluded property. Part 8, disposal of property. Again, this part is not in Form 13 and is not necessary for support issues. And this part is hardly ever filled out in reality. As a court may, on the rare occasion, order that net family property not be equalized, where one spouse has recklessly depleted the asset, it is necessary to show on the financial statement assets disposed of in the preceding 2 years or since marriage. If you think your spouse recklessly depleted assets, please advise me or your lawyer, and it will be discussed separately. This part may also show that assets that have been improperly given away. If there is a large total value in this section, please give a written explanation as to why the asset was disposed of. However, as I said, generally this section is left blank, and we're not looking for minor disposal of assets, but big ticket items. And remember, these videos are not to be used as a replacement for legal advice. You should still consult a lawyer.